Good morning, everyone. Can everyone hear me well? There's like a microphone at a distance, so hopefully this is a good sound quality. My name is Caroline Cecot. I'm a professor here at the George Washington University Law School and part of our Environmental and Energy Law program. I am truly delighted to welcome you all to the 2026 J.B. and Maurice C. Shapiro Environmental Law Symposium at GW Law. This symposium is one of GW Law's signature annual events. Each year, it brings together leading scholars, practitioners, policymakers, and students to grapple with the most pressing environmental and energy challenges of our time. It reflects not only the intellectual strength of our program, but also our commitment to scholarship, service, and dialogue. This year's theme is adapting to paradigm shifts in environmental and energy law in the United States. And it comes at a moment that feels like a crossroads for the environmental movement. Climate change, political dynamics, technological innovation, and resource constraints are all challenging existing legal frameworks. At the same time, new approaches are emerging to promote sustainability, accountability, and resilience. In short, we are witnessing a period of profound change, what we've called paradigm shifts, in environmental and energy law. But in some respects, this moment also feels like a paradox. Our understanding of environmental harms has become much more refined over time. We know far more today than we did decades ago about the relationship between pollution and health. For example, the scientific literature connecting the exposure to fine particulate matter and human mortality and morbidity is now very well developed. Our methods are better, our data sets are bigger, our modeling is more sophisticated than ever before. Similarly, on climate change, the scientific community has continued to narrow the uncertainties about mechanisms, trajectories, and impacts, even though questions remain about precise magnitudes or timing of future changes. Across areas, our knowledge has grown, providing a much firmer factual foundation for policymaking than in the past. In parallel, economic analysis has developed tools to translate some of these health and risk effects into monetary terms. Imperfectly, yes, but defensively and transparently, so that benefits and costs can at least be compared on a common footing. Decades of research in environmental and energy and labor economics have given us methods to monetize mortality risk reductions based on people's revealed preferences and stated preferences when they're making their own decisions about risks, and allowing environmental benefits like lives saved to be evaluated alongside the compliance costs of regulations. The idea was never that dollars define moral worth, but the idea was that analytical transparency builds legitimacy and helps decision makers see trade-offs clearly. We have also become more attentive to distributional issues. We ask who benefits and who bears the burdens of pollution and regulation. We talk about cumulative exposure to multiple pollutants. We talk about inequities in access to clean air, water, green space, reliable energy. And these concerns about environmental justice have become central to the conversation. I'll admit that I long thought, perhaps naively, that as our scientific understanding improved and as we became more transparent about environmental trade-offs, we would all come together closer on appropriate policy and lifestyle choices. Or at least, if everyone could see the same evidence of tangible benefits and costs, the path forward would become less contentious. So here's the paradox. That has not happened. Instead, we are living in a period of increasing polarization around many issues, but especially environmental issues. Public opinion data show widening partisan divides on core questions. For instance, large majorities of Democrats say human activity contributes a great deal to climate change, whereas very few Republicans share that view. Likewise, many Republicans believe media coverage exaggerates the seriousness of climate problems, a view rejected by most Democrats. We see similar divergence in trust towards institutions. Overall trust in scientists remains relatively high, at least compared to other institutions, but there is now a substantial gap between the political parties. Democrats express much greater confidence in scientists to act in the public's interest than Republicans do. And trust in the federal government more broadly is at or near historic lows across the board. What I find striking is that this partisan divergence has grown during a period when, objectively, scientific methods have become more rigorous and data-driven and clear. And it suggests that our debates are being driven by factors beyond just facts, whether it's identities, values, ideological filters, distrust, and that greater scientific clarity alone is not enough to bridge that divide. Let me briefly mention two recent regulatory developments that, to me, illustrate this paradox between strong evidence and policy divergence. First, the US Environmental Protection Agency has just finalized its rescission of the 2009 greenhouse gas endangerment finding for motor vehicles. The endangerment finding was issued after the Supreme Court's decision in Massachusetts v. EPA, holding that greenhouse gas emissions can be air pollutants under the Clean Air Act, and they can be regulated by EPA if they endanger public health and welfare, and thereby respecting the broad definition that Congress enacted in that statute in order to equip the agency to respond to important emerging problems. The finding has been the legal foundation for federal regulation of greenhouse gas emissions under the Clean Air Act for more than a decade. Rescinding it is an extraordinary step. Not only does it roll back the formal determination that greenhouse gas pollution from motor vehicles endangers public health and welfare, but it also entails repealing federal vehicle greenhouse gas standards program and other greenhouse gas regulation under the Clean Air Act that stemmed from the finding. What's notable is that the EPA's rationale in the final rescission does not rest on any new climate science indicating that greenhouse gases are suddenly not a danger. That would be difficult, as the scientific consensus on climate risk has only strengthened since 2009, though that's not to say that the EPA did not try. The proposal a few months back did attack the scientific basis. But after an outpouring of scientific evidence into the decision-making record, the agency pulled away from that rationale, saying in the final rule that it is not finalizing that additional basis for repeal. But no, that didn't lead to a rethinking of the move. Instead, the rescission rests on a reinterpretation of the Clean Air Act, a conclusion that EPA lacks, actually, statutory authority in this area. So we are now going to revisit a finding about statutory scope, a finding that I thought was legally settled by the Supreme Court, and not too long ago, and now at a time of even more evidence and knowledge about dangers. It's one example of how a paradigm shift in policy can occur despite the weight of scientific evidence going in the other direction. Second, the EPA a few weeks ago chose not to monetize certain health benefits in a rulemaking, specifically the benefits associated with reductions in fine particulate matter and ozone, citing uncertainties. A rationale, by the way, that is actually repeated in the formalized rescission of the endangerment finding. For decades, under administrations of both parties, federal agencies have monetized the benefits of environmental interventions using well-established scientific and economic methodologies. The process relies on roughly two steps. One uses information, scientific epidemiological information that connects pollution and health outcomes, and the other uses economic information from labor market studies and other surveys from people's revealed and stated preferences about how much they value risk reductions in their everyday lives. When used appropriately, these methods have allowed health benefits to be compared against compliance costs in a consistent and transparent way. The EPA's rationale was essentially because there's uncertainty in the precise magnitude of these health benefits, we won't monetize them at all. And it is true that there is uncertainty. There's always uncertainty in any projection of estimated benefits or costs, and that uncertainty is usually reflected through ranges and sensitivity analysis for benefits and costs. By refusing to monetize just the benefits while continuing to monetize the costs, the agency didn't remove uncertainty from the process. It simply introduced an analytical bias. It made the benefits appear to disappear from the cost-benefit calculus by leaving them unquantified, whereas the costs remained front and center in dollar terms. And that changes the way the trade-offs appear on paper. And that is what concerns me. One of the successes of the last several decades was that environmental benefits, especially health benefits for which we've been able to gather data, and that's not even always the case, but they were increasingly evaluated at the same footing as costs, forcing decision makers to grapple with the evidence on both sides. This practice did not guarantee pro-regulatory outcomes, nor did it eliminate disagreements, but it did promote analytical integrity and transparency, and it set up a sort of, these are the rules of the game. And if you want some kind of a change, show us the science, show us the evidence type of process. Moving away from monetization without offering some substitute framework for weighing those benefits, those risks, trade-offs, how to trade them off, risks a return to a more impressionistic, ad hoc mode of decision-making, one that depends heavily on institutional trust. But this time, it's sort of the government saying, just trust us, that the unmonetized benefits are not really that big or important after all. Institutional trust is already fragile right now, and this won't work or help things. And these are just two examples. Revisiting the endangerment finding and abandoning benefits monetization, they're different on the surface, but they both reflect a broader paradigm shift, a shift away from established practices that were built on scientific evidence and analytic conventions. And in both cases, the underlying science hasn't changed dramatically, or if anything, the evidence has strengthened. But what's changed is the political and legal context, driven by ideological polarization and perhaps an increasing skepticism of expert analysis. There's another dynamic that adds and layers on this that makes me less confident in that simply improving the information we have will bring us all together. And that's the fragmentation of information in our society. We have unprecedented access to information today. Anyone with an internet connection can read reports that are coming out of the government. You can read the cost-benefit analysis. Some of you in this room have already read the 450-page endangerment finding, I bet. We all have access to this, yet we don't necessarily all consume the same information. Different audiences gravitate toward different sources. We read different summaries. We watch different media outfits. We follow different experts. So this means that even if the underlying science is evolving in relatively consistent terms, our perceptions of it can still diverge wildly. Abundant information hasn't translated into a shared understanding, and in many ways maybe even allowed folks more flexibility in picking the kinds of sources that they want to think about. This divergence in information and beliefs adds to the challenge of making durable policy. It is hard to craft laws or regulations with broad support if we can't even agree on the facts or if we lack a common baseline of trusted information. Issues in environmental law tend to require a long-haul approach. Tackling issues like climate change or species conservation or air quality isn't something you can do with a quick, one-year policy that you can then reverse the next year. These efforts require multi-decade commitments and consistency. Yet we're seeing whiplash in environmental policy. Even recent foundational statutory interpretations are now potentially in flux with shifting judicial philosophies. This kind of regulatory instability carries its own costs. It creates uncertainty for communities and businesses planning for the future. It discourages long-term investment in solutions. If everyone assumes the rules will change, it is hard to make any commitments. And frankly, it adds to cynicism among the public. Stability and predictability in policy are important values of themselves, especially when the problems are long-term. But stability is hard to achieve in a polarized environment with fragmented information and low trust. Okay. Let me have a moment. So I've teed up my concerns. If this was a law review article, we're now going to the usually very short section on solutions to the problem. But I don't have any solutions. I don't think any one person has any solutions if they're being honest, and I hope one takeaway from my conversation starter here is that I value honesty. So I raise these issues to set the stage for careful thought, the kind of thought that we intend to pursue during this symposium. That is why I am so grateful for the structure of this symposium. We've assembled panels that each address a different dimension of this crossroads moment, and we've done so in a format that encourages sharing of expertise and discussion. So over the next day and a half, we will hear from people who've been thinking deeply about various issues for years, over careers. Our first panel, coming right up, New Approaches to Climate Accountability, asks how we respond when political processes fail to address climate change adequately. How timely. The panel will be followed by a keynote address by Professor Charles Lee, reflecting on the environmental justice movement that he's devoted his career to and ways forward in this moment. After lunch, we'll award the student winner of the Grodzki Prize for Environmental Scholarship, followed by our second panel, New Approaches to Environmental and Climate Justice, which pushes us to consider distributional equity more seriously. How can laws and regulations be designed or reformed to ensure that all communities, especially those historically overburdened by pollution or most vulnerable to climate impacts, are protected and empowered? Our third panel, New Approaches to Adaptation and Resilience, recognizes that some environmental changes are already underway. How should we adjust our land use, infrastructure, disaster response in light of heightened risks like sea level rise or water scarcity? At the end of today, we'll get some reflections from my colleague, Rob Glicksman. Our program then continues tomorrow, but in a different room. So don't come back here. Join us in the Student Conference Center. And it'll start with a warm welcome from the Dean of GW Law, Dean Dana Bowen Matthew, who will share her thoughts as the future of environmental law and justice is close to her heart too. We'll follow with a panel on paradigm shifts in US energy law, which zooms in on the energy sector, which is undergoing its own transformation from the rise of renewable energy and energy storage to challenges of modernizing the electric grid. Later on Friday, we'll have the panel I'm moderating, market mechanisms for climate and resource sustainability. We'll talk about water markets, payments for ecosystem services, and corporate sustainability approaches, and ask whether market mechanisms can still offer cost-effective, common ground solutions in this moment. Finally, our capstone panel, Paradigm Shifts in US Environmental Law, asks the big picture question: are our foundational environmental statutes and doctrines equipped for this era of rapid ecological, technological, and social change? My colleague, Sarah Brennan, will then close our conference with some thoughts. I no longer assume that greater scientific refinement will automatically bring consensus in our society, but I believe that people care about our world and each other. I believe in the value of shared inquiry, and I believe in the mission of institutions like law schools to foster dialogue and critical thinking. I believe academic conferences and symposia on important, even if contentious topics, are more important than ever. We may not leave the symposium with full agreement on solutions or paths forward or any solutions, but perhaps we can all leave with clearer thinking, stronger professional relationships, and a deeper appreciation for the institutional structures and good faith processes that make durable environmental law possible. Thank you to our environmental and energy law program team. I don't see Claudia, but especially Claudia Delgado, to our student helpers from the GW Journal of Energy and Environmental Law, to our fantastic speakers, and to all of you for being here and contributing to this important conversation. I am very much looking forward to the discussion ahead. And with that, I am delighted to kick off our first panel on climate accountability, but we're going to take a short break to allow the panelists to set up, and we will reconvene in this room at exactly 10:45 a.m. Stay tuned, and thank you.
Perfect timing, everybody. I love it when that happens in a class, right? You're standing there waiting to shout at everybody to stop, and then it just happens like this. Anyway, hello, good morning. I'm so glad to be here. I'm very grateful, and I think we all are, to GW for organizing a really spectacular conference, and thank you for those opening remarks. This panel is about climate accountability. And I think when it was planned, we didn't expect a new entry into the sort of questions about climate accountability like we saw last week, which is, of course, the repeal of the endangerment finding for greenhouse gases. And so we're going to talk about some other things as well, and then it may well be that it turns out to be interesting and relevant to talk about the U.S. Decision last week. So on the panel, and you all have speaker bios that are more lengthy, but we've been asked just to say the names and the affiliations of the speakers, and I'm happy to do that. We have Outka from Kansas, who is an expert in energy and environmental law, and Don Braman from here, from GW, who is an expert in criminal law and criminal justice reform. And they're both going to take some time at the outset to talk about matters within their particular expertise. Outka will be talking about international frameworks for climate accountability, and plus I think that'll naturally lead to some observations about the U.S. role in those frameworks. And then Don Braman will be talking about the potential for criminal law to create a kind of accountability for climate change. So that's where we'll start. Sadly, Aisha Saad is not able to be with us this morning. She was going to talk about insurance markets and private governance as possible means of climate accountability. So it's too bad not to have her, but we've got a great panel nevertheless. So thanks so much for coming, and I'll start with Uma.
Thank you so much, Lisa. Is this working? Can everyone hear me? Just absolutely delighted to be here. Thank you to the fantastic GW faculty and staff for hosting this event. Caroline, what an amazing opening. Thank you so much. I just made us all so excited to be here. Really glad to be on this panel as well. The overarching theme of climate accountability connects to so much about this moment in energy law, in environmental law, in international climate change law, of course, in climate change litigation, but also in law practice and even in legal education. So panels throughout the symposium, as Caroline described, will delve into many of these areas. And so in this opening presentation, I want to lay what I hope will be some useful groundwork for some of what's to come in the rest of the program by framing new approaches and new developments that we'll be learning about in accountability terms. So of course, by its nature, any discussion of climate change, even when focused on domestic law and policy, has global dimensions. So let's consider new approaches to climate accountability first from the big picture perspective of global engagement and climate progress in the international climate change regime. Let me make sure I have my timer going so I don't go too long. also in terms of both the climate change regime over time, but also in the most recent Conference of the Parties, COP30 in Belém, Brazil. I just want to start that beginning of this conference focused on climate. Let's have some of the visuals in front of us. Some of us spend a lot of time with these, others don't. The United Nations Framework Convention on Climate Change, the UNFCCC, is of course the world's treaty framework for collective climate accountability. So it's really collective honesty is what it's meant to be about what's happening to the climate combined with the core concept of common but differentiated responsibility and respective capabilities. So the United Nations, this is just the latest of the emissions gap reports, confirms, right? The world's not curbing greenhouse gas emissions at nearly as much or as quickly as needed to be accountable to the UNFCCC commitment to the 1.5 degrees Celsius mark. GHGs would have to be peaking, basically, and reducing to declining in the range of 40% by 2030. We're not on track. The emissions gap is real. But this work is part of the accountability of tracking that, of knowing that and sharing it globally and addressing it as a global community. Climate adaptation, though it's important everywhere, so the panel coming up will detail, it's one of the most critical areas of sort of flashpoints for accountability in the UN process, how to fund adaptation measures that protect against climate harm for the most vulnerable, how to create accountability for loss and damage that's already occurred as a result of climate impacts. And so the backdrop for this, all of these larger climate accountability questions, and a key reason why international climate negotiations are slow and fraught is, of course, this, in part, the dominance of top emitters in terms of the total carbon dioxide emissions that are emitted today, but also this, right? The top emitters per capita are a different cohort with wide-ranging national circumstances that reflect the difference from the first slide to the second. And then also this, right, that the US and the EU have the highest accumulated fossil carbon emissions since 1850, but with China now being a close third. So taken together, as the Paris Agreement particularly recognizes, all reductions matter, right? Even though the rest of the world is grouped together, it's and individually so small compared with the top emitters, cumulatively it still matters. That's a core sort of agreement within built into the Paris Agreement. And so all parties are called on by the Paris Agreement to reduce emissions with increasing ambition, which is the shared accountability in pursuing the common goal, still common but differentiated, right, under the original treaty. So looking at the last 30 plus years of international and domestic climate efforts under the UNFCCC, it would be fair for casual onlooker to think there's nothing new here. We need new approaches, right, to climate accountability, that if this process isn't getting us where we need to be. And even avid participants in the process are frustrated when each year a Conference of the Parties ends with something less than those seeking urgent progress had hoped. But when we look back over the 10 years since the Paris Agreement, the fact of an enduring structure for climate accountability is, we're reminded, no small thing to take for granted. So while the rest of the world remains formally committed to restraining global temperatures to well below 2 degrees Celsius above pre-industrial levels and detailing nationally determined contributions that they will make to global climate change mitigation, the US has now withdrawn for the second time from the Paris Agreement in an executive order last year, went into effect end of last month, and also now declaring the intent to withdraw for the first time from the underlying treaty, the UNFCCC itself. So I attended COP 29 in Baku, Azerbaijan, as official observer, speaking delegate for the American Bar Association. After the election, November 2024, but with the US still officially represented, it was awkward. The US even submitted a new NDC, the required NDC update, with increased ambition, right? Knowing it was a submission that wouldn't have the support of the incoming president. But at COP 30 in Brazil, which I was able to join some of as a virtual delegate, the United Nations Climate Change Executive Secretary Simon Steele isolated something that to me was really important. This year, there's been a lot of attention on one country stepping back, he said in the closing session, but amid the gale force political headwinds, 194 countries stood firm in solidarity, rock solid in support of climate cooperation. 194 countries representing billions of people have said in one voice the Paris Agreement is working and resolved to make it go further and faster. So were the results, there's been incremental progress toward greater climate accountability at every COP, right? Some more than others. Were the results path-breaking at COP 30? I think most people would say no. But were new approaches still being developed? Were new improvements and refinements to transparency and accountability being developed? I think there we could say that there it was possible to move the stakes despite the uniquely challenging circumstances in the climate accountability lane. And so one aspect is a sort of new approach, which is carrying on without the US. And the fact that that occurred is itself, I think for many people, significant, a gesture of importance that multilateralism still has a possibility. And so a few of the things that were decided there, the Global Muchiro was a collective effort document that did several things, tripled adaptation finance. As with anything at the COPs, right? The devil's in the details. But the parties decided to urgently advance actions to enable the scaling up of financing for developing country parties for climate action from all public and private sources to at least 1.3 trillion per year by 2035. So that references the new collective quantified goal that was set at COP29. And they emphasized also the 300 billion per year. Without the US there, the fact that that conversation continued is significant. The Belém adaptation factors, the global goal on adaptation in the Paris Agreement had never really been measurable. This was the first COP where parties articulated a series of factors that would be used to measure progress on the global goal on adaptation. And so 59 voluntary, as is the case with these agreements, voluntary indicators covering themes such as water resources, food security, health, ecosystems, capacity building, and established a 2-year framework for operationalizing those indicators. A Brazil-led proposal to compensate countries for preserving tropical forests, with 20% of funds reserved for indigenous people. A new approach attempted, entirely new, there's been coalition efforts before, but an effort to kind of organize outside the central negotiations. A coalition of over 80 parties gathered together to try to advance progress on the commitment made at COP28 to transition away from fossil fuels. That was not successful in getting those countries represented about 7% of global emissions, so it did not have that, they didn't succeed in bringing it to the fore, but they did get the COP president to have to say, we will address this in 2 meetings following the COP 30 and before COP 31. Also notably, for the first time in a COP text, the parties acknowledged that it is likely to overshoot 1.5, right? And that the extent and duration of that needs to be limited. that's important to the climate accountability of honesty, right? So even though 1.5 is in the UNFCCC, to acknowledge that overshoot is likely is also important. So outside of the COP and UNFCCC process, 2025 also marked a new international approach to climate accountability, which involved clarification of international legal obligations respecting climate change from the International Court of Justice. And the road to this opinion, all the professors in the room would love this, is a class of international environmental law students at the University of the South Pacific, but it prompted many states around the world to participate. So a large majority of states and international organizations, especially states that are very vulnerable or especially vulnerable to climate harms, sought confirmation from the ICJ that there are expansive obligations under international law to address climate change besides just what parties have committed to in the UNFCCC and the Paris Agreement. The US and other big emitters argued the climate treaties provide the only relevant obligations, and in any event, those are discretionary, the degree to which states decide to reduce emissions. The ICJ sided with the majority of states and rejected unanimously the arguments of the large emitters. And so this is a new approach in international law, new clarification. So I just show you the front of this book because it's a collection of essays addressing this and providing really useful history around this topic. But essentially, the ICJ opinion details 5 sources of the most directly relevant applicable law in respect to climate change, climate treaties being obviously one, but not only, also customary international law, other international environmental agreements, law of the sea, international human rights law. And so I also give, for those interested, a reference to a sort of short primer that's helpful in understanding this opinion. But at the most, at its most basic, this new approach to climate accountability affirms that climate change mitigation is required by general international law principles, imposing a duty to prevent significant environmental harm and applying not only to instances of direct cross-border harm, but also to the climate system as a whole. So intricately connected to these international efforts to advance climate accountability are the domestic efforts of individual parties. The U.S. obviously withdrawn its NDC, but over 130, I think it was 134 last I looked, countries had already submitted their updated NDCs. And so in the U.S., there are states that are recommitting now to coalition-based work in service of the targets outlined in the US NDC that has been withdrawn. So we're seeing, at least in the climate context, a fracturing of US participation devolving further to the sub-federal level in that international process. So the US Climate Alliance, it was first formed in 2017, so it's not a brand new organization, but the new significance of state leadership has led this group of states to focus on new approaches to strategic coordination of effort. And in essence, so this map just shows you which are the 24 states advancing state-led climate action in bipartisan coalition and the percentage of the population and economy they represent. What they've focused on in the last year is essentially climate gap filling, right, with a focus on collective state action in defined policy areas. And as the graphic shows, the Alliance members are aiming to help mitigate the loss of federal leadership by continuing to raise the ambition in climate targets while also identifying new strategies. So in December of 2024, after the election, after COP29, the Alliance specifically adopted a new collective target to reduce GHG emissions by 61 to 66% below 2005 levels by 2035, which directly aligns with the US NDC that had been submitted by the outgoing administration. And then expanding beyond just the Alliance states, but also in coordination with them. America's All In is an example of a more expansive coalition that's taking a what they call whole of society mobilization approach under the leadership of former EPA Administrator Gina McCarthy. So this means cities, but also states, but also cities, businesses, schools, institutions of faith, health organizations, and aiming to elevate the role of non-federal actors in climate leadership, including at COPs. And if you look at the document that came out of COP30, those very groups were specifically encouraged and elevated by agreement of the parties to continue to participate and increasingly participate in that process. So here they are projecting how enhanced actions from leading states alone, if they get no other help, and projecting out, okay, well, what if we had renewed engagement by the federal level after 2028? They're sort of envisioning what are the different possibilities. But just leading states alone would be, there's still the potential they see to achieve a 44% reduction by 2035 with active collective efforts. So combine that with expanded possibilities and maybe a post-2028 reinvigoration of federal efforts. It could be more, but this is the kind of thinking they're doing, the kind of coalition building they're trying for. Again, it's a new way of envisioning climate accountability as gap filling, but also as alternative coalition and coordination strategies in their own right. Staying with the states, let's consider examples of new approaches there. We saw the coordinated push on the 2 slides ago to advance a suite of policies by collective action, but each state is also defining its own course. And the most prominent examples, many of us are reading about them in headlines on a weekly basis, is the new approach states are taking to climate accountability modeled on CERCLA, the longstanding federal Superfund law that holds potentially responsible parties strictly liable for cleanup costs at contaminated sites. So the climate Superfund laws essentially are mirroring that effort to impose strict liability on the largest fossil fuel companies for a portion of the state's climate adaptation expenses based on emissions associated with the sale of their products. So New York and Vermont are already embroiled in litigation. There's lawsuits brought by chambers of commerce. The president issued an executive order, 14260, specifically instructing the attorney general to take action against states with climate Superfund statutes, and the DOJ has complied with that directive. So all eyes will be on that litigation as time goes on this year. A wholly different approach that I just want to raise shows you just how wide and varied these state efforts are. This one's really interesting to me. It's an example, because I also teach property. This is an example where Connecticut's taking a climate risk information strategy of reveals details about every property's climate risk. This is a way to empower and inform citizens. It's the first state, as far as I'm aware, that's looked to display this extensive of climate information about property to educate residents about climate impacts, particularly flooding, which is important because in the US, about 2/3 of residential flood losses are uninsured, which can be just devastating to the financial well-being of the household. So at the same time, these are state demonstrations of different approaches to climate accountability. And sometimes they may be framed in ways that don't mention climate, right? There may be, for example, long-term water security efforts. This is a big focus in the state of Kansas right now. May not focus on this as, call it climate adaptation work. It's climate adaptation work, right? This is lawmakers trying to secure water. We know the reasons that this is, that climate is one of the factors creating pressure on aquifers. So finally, we are, as ever, seeing new approaches in climate change litigation. Lawyers are working really hard right now, doing some really impressive work, and it's a moment demanding lawyers full range of intellectual capabilities and creativity. So according to the Sabin Center's recent count, The US is by far the most dominant site for new climate-related filings globally. And I just want to highlight two examples to give a sense of the variability. One is from the long list of lawsuits against the Trump administration for freezing funds that were authorized by Congress for purposes that are now disfavored by the White House. One of these disfavored programs, Solar for All, was authorized with $7 billion in the Inflation Reduction Act to expand rooftop solar and community solar to low-income and disadvantaged communities. And it was projected to reduce energy bills for 900,000 households. It was projected to have climate mitigation benefits, also for local air quality. So there's 4 lawsuits pending. And think about the different theories these lawyers have come up with. On the one hand, you have 22 attorneys, state attorneys general, who are bringing a breach of contract claim in the Court of Federal Claims, claiming EPA unilaterally terminated Solar for All grants in breach of contract. They're seeking money damages. Then we have 3 district court cases on the same issue, one of which has the same plaintiffs as the Court of Federal Claims case, and they're alleging violations of the Administrative Procedures Act and the Constitution, separation of powers, and other theories. So a second example, Michigan's AG's antitrust suit charts new path for climate torts, right? This is another one where we've seen a lot of common claims asserted in lawsuits from states and local governments in state court about violations of state common law, consumer protection law based on fossil fuel companies' alleged concealment of climate risks that were known about their products. In this lawsuit, it's a claim that the oil companies colluded unlawfully to restrict renewable energy and delay transition away from fossil fuels, and that is an alleged violation of antitrust law. So really, so much creativity right now in the legal field. And so in closing, I just want to center the question of climate accountability within the legal profession as well. Lawyers are doing incredible work, and supporting them, as well as the next generation of lawyers, is critical to bar associations and legal education. This is a report that's just to indicate the engagement of the International Bar Association, the American Bar Association, and others focused on this topic. And Resolution 513 of the ABA resolved that ABA urges lawyers to learn about sustainable development, counsel clients on related risks and opportunities, provide resources to assist lawyers to incorporate sustainable development into their practice. Accountability for us in legal education likewise has to involve preparing students to be attorneys serving clients facing evolving climate risks, right? That ties directly to ethical and competent representation, whatever the focus of their practice may be. And this calls on us to continue to offer the chance to learn about international climate change law, the range of climate change-centered domestic legal strategies that have been proposed, some that were adopted and are being reversed, but also those that remain enacted law. So thrilled to be here with you, and very happy to turn it over to Dawn for the next presentation.
That was so informative and even thrilling.
Turn this off for you.
Thank you.
Thank you, Lisa. Thank you, Dawn.
Thank you so much, and I really thank you to all the organizers. I appreciate all of the organizing that the students and the faculty have done for this event, and I also appreciate that you ended on antitrust, which has a criminal element and is one of the predicates for prosecution that states are looking into. Just to give you a little bit of background in terms of why I'm here, because I'm a criminal law professor, I'm not an environmental law professor. I work with prosecutors around the country on issues that keep them up at night, basically. At the low end for reforming their criminal justice harms to communities, to the high end of the real harms that huge corporations do in their states, but that they're not equipped to address, and they want to be equipped to address. And I think I spend most of my time working with those prosecutors, but also with other law professors in different areas of the law that I'm not so familiar with, like environmental law, but also like corporations. I work a lot with Teresa Gabaldon, who's a fantastic corporate law professor, Steve Schooner, who's ubiquitous at GW and who does procurement law, state procurement law. And so we've been working together with advocates and with state and local prosecutors, looking at what are the options that are available to them. And what I've learned is that many of the solutions are going to have to be global, but that in the United States, as you were just letting us all know, for the foreseeable future, it looks like it's going to be state and local remedies, not federal remedies, right? And I want to maybe ground this, and I'll see if I can channel Teresa here a little bit, in the structural reality of what corporate law looks like in the United States today. We, and by we, I really mean the Supreme Court over the last 50 years has empowered corporations, giving them lots of rights and the ability to disregard a lot of the regulatory schemes that the public was demanding and that legislators were enacting. And we are now faced with the consequence of that, and very prominently in the context of climate. And so the question is, what can we do if you want to solve a problem in the United States? You used to think like, oh, we go to the federal level. That's how we're going to solve this problem. And maybe through a political solution involving massive political transition of electeds and appointed judges of the Supreme Court, that will happen. It's going to take a lot of work and a lot of time. At the state level, the court has actually done a fairly thorough job of preempting state efforts to regulate climate change civilly. What the federal system carves out from that is a respect for state criminal law. So that's where I come in. That's why I'm here at an environmental law conference. And in theory, it kind of has a really appropriate hook for this type of conduct. There are not only charges of fraud that states are considering, that could be predicates for conspiracy and racketeering charges. There are antitrust considerations. We have both state and federal antitrust laws. So the state laws are predicates for prosecution there as well. There are also other types of offenses that many prosecutors believe fossil fuel companies have committed, including reckless endangerment, public endangerment, risking or causing a catastrophe, risking or causing widespread injury or damage, and even homicide. Those are all very interesting criminal potential predicates for a prosecution at the state or local level. But what would it get you? In this context, I think we need to have the fossil fuel companies be part of the solution. I am not a lock people up and throw away the key type of criminal law professor. I am a rehabilitative and restorative justice kind of criminal law professor. And to my mind, that opens the door to a lot of possibilities with these very powerful and very large corporations that have a huge impact on state and local communities. So I want to be very clear that I am not saying that we should be locking up fossil fuel executives or anything like that. And in fact, I think that the recent Purdue Pharma settlement is a nice model for what could be possible at the state level. If you're not familiar with the settlement, I'm sure everyone's familiar with Purdue Pharma and the massive, horrifying epidemic of opioid addiction that Purdue Pharma contributed to and fostered across the United States by pushing opioids. So federal prosecutors encourage them to restructure as a public benefit corporation and to use all of their resources to help combat addiction while providing legitimate pain reduction medication to hospitals that need it around the country. Large corporations like that do a lot. They employ a lot of people, they have a lot of resources, and I think it would be a mistake to try to cut them out of our economy. I just don't think that that is likely to work. And so instead, with the help of corporate law professors and procurement professors and state and local prosecutors and electeds and former prosecutors who are forming a kind of loose coalition to support these efforts, we're proposing that states ask the fossil fuel companies in a prosecution for a settlement that requires them to do business in the state through a public benefit corporation with transparency reporting and enforcement hooks embedded in the charter of the corporation itself. This view, I think, rests on a kind of realization that large corporations have become so powerful in the United States that it is very difficult to cabin their behavior. And so this is an effort to start, at least at the state level, to provide some type of accountability and using the criminal law as a kind of hook to establish the legal grounds and leverage the legal bargaining leverage with these large corporations to do that. I will say, and Dick Pierce pointed this out to us when we presented this idea a long time ago, that the greatest barrier to this is not that prosecutors don't think crimes are being committed or that there's a structure for some kind of solution that they could get, whether it's the one that we propose or another one that involves super funds or some other solution. It's that these corporations are so large that they are considered by most people to be pretty much above the law. They are untouchable, in Dick Pierce's words. I don't think that's true. I think that this is a collective action problem. And as we were just learning, states are good at solving collective action problems where there's a will. And I think gathering people together in order to try to solve this type of collective action problem is one possible path forward. It's definitely not the only path. We need a lot of paths forward if we're going to get something constructive out of this current situation. But that is the hope that I see with the folks who I work with on the ground, who are very practical people, who are thinking about their communities and the harms that their communities are suffering in the wake of real climate disasters that are harming and killing people in their communities. I don't know that it's going to be successful. I know that there are concerns about the politics of it and backlash, but that's the kind of work that I am interested in doing. And if you're interested in doing it, I'd be happy to talk to you about that.
Wonderful. Before turning to questions, I just wanted to give you, I know you just spoke, so maybe you've said your piece, but I just wanted to give both of you a chance to talk about anything you missed or didn't get a chance to talk about or anything more broadly. You good?
I would just say that we're missing the insurance piece here,
Yeah.
which is the I feel
Yeah.
it's sad one of our panelists is ill, but it's such an important piece. You probably, or maybe, I don't know which of you knows more about it, but both of you probably know a lot more about it than I do.
And maybe it will come up in climate adaptation discussions
Well,
later,
so,
but
yeah.
yes, one of our panelists was going to talk about insurance and the role of insurance within the climate accountability context. And, insurance companies do know, they track climate risk because it's exactly what affects their bottom line. And that is an area that states will end up, having to fill the gap to cover people over time.
And I know that the specific topic was going to be how to think of insurance subrogation, stepping into the shoes of the person who was insured and taking over claims that the insurance company might therefore have against the injuring party, and how that is actually a governance regime, thinking about that as a governance regime, and thinking about how to sort of harness it in the service of tackling climate. And that's about all I know about insurance.
I'll add one more layer to this, which
Yes.
is that a lot of insurance companies, like a lot of hotel companies, like a lot of other large corporations, incorporate at the state level to do business in that state consistent with state regulatory and criminal codes. And so I think it's one area where I think state and local has some say in what might happen.
Interesting.
So I think questions.
Sure.
Dick.
So I had a question for Uma. I love your slideshow. I think it really tells a very important story. But there's two slides I would add that caused me to be a lot more pessimistic than you seem to be. After your slide where you show the black states doing good things and the white states doing nothing, okay, I would add two slides. The first slide is internal migration patterns. The black states are losing populations every day, almost every one of them, led by California. And then the other one, and the white states, of course, are gaining population every day. And then the other one I would add is cost of gasoline and cost of electricity in each of those states. And that would help to explain these internal migratory patterns that cause me to be very pessimistic. And it fits with the polling data that shows that if we assume this is all free, then there's a strong majority in support of it. You add $1 to monthly electricity bills and you lose the majority. And of course, the problem with solar and wind is the unit costs are very encouraging, but they're intermittent sources, and that adds enormous cost to the overall system. So why am I wrong to be concerned about all that?
I'll give a quick response, and then I see Jim also. Also, it's really nice to see you again, Dick. I think, look, pessimism and optimism is which day is it in a way, right? In this area, we're going to feel bad. Some have the cup half empty, cup half full, depending on the day. The departures from states, I don't have maybe as much information as you do about that. Certainly, energy affordability is a huge concern. There's, I think maybe I would differ on the reasons why the prices are going up. In some areas, I think there's a lot at play, and I think maybe on our energy panel we'll get into some of those issues. But I think the point of so I don't think that I need to say that you're necessarily wrong about some of the trends that you're observing to say that those states that are working together are, through coalition building as a new approach to climate accountability, better positioned to address that than they would be otherwise. Look, we have regional transmission organizations, we have a regional grid, a lot of different factors go into the prices, and I don't know that just that would be the reasons that people are leaving states, but I need to learn more about that, I think. Jim, did you want to follow up?
As a friendly response, I'd like to add a slide also to you.
Great, bring it on.
California is the 5th largest economy in the world, right? I mean, losing some population is 4th. All right, hey, are even better. A different slide. So I mean, yes, internal immigration, migration matters, but that's not, I think, where the action is. But it ties to a question I wanted to ask actually all three of you, because Lisa, I know you've done stuff with this as well, and that is the whole sort of role of the federal government in this. So we know that they're already kind of preemptively address these Superfund laws. You've got an administration that is dead set, very clear that they're going to fight everything. You've got a Supreme Court, the way they dealt with the Clean Power Plant certainly are not friendly. And so, Don, you were saying, we can do this in the states. I'm not a preemption expert, but I am curious if you all could reflect on whether really anything in the States is safe from federal, a sort of federal caution, if you want to put it that way.
We had such a nice little moment of positivity. Now with the very first two questions. So I'll take on just a little bit of that. I do think we cannot underestimate the level of power being exercised by the federal government now to shut down any action on climate change, whether it's at the federal level, the international level, the state level, local level, people's random tweets. I mean, it is an incredibly whole of government approach to eradicating climate regulation. I don't think we can deny that. And so, and we have a Supreme Court that has been very quick and enigmatic in responding to the lower courts' judgments about how the government is overreaching. And so there's nothing, there may be no bottom to this at the moment. And I think thinking about like new ideas is totally great. Why? Because we need to, and because the dust will clear on this and things will settle, and then we'll need to figure out what to keep and what to let go. And so it seems to me that, yes, there's a risk to all of this. There's a risk to preemption. EPA has a theory about why, even though it's undoing the auto vehicles regulation program for greenhouse gases, the Clean Air Act still preempts state action. It has a theory about why, even though the federal greenhouse gas regulatory program will be undone for every source under the Clean Air Act, that it still manages to displace federal common law. We'll see. We'll see. But they have theories for all of that, and they just need to be, I think, this is why the reminders about lawyers' obligations and opportunities really are so important, that these cases are being litigated one by one with incredible painstaking arguments. And so it can seem like, sometimes I feel like, oh my gosh, Supreme Court is there to pounce, right? At any moment, they're just gonna pounce and undo a stay that was hard won. Yeah, that's sort of what they're up to these days, but not all of them, right? And so I guess I'm agreeing with you that those things are potentially vulnerable, but we don't know. This is really, it seems like maybe it's been 100 years, but it's really early days. It's a year in, and we don't know how all of this is gonna land. And if you read something like, I'll just say, if you read the repeal of the endangerment finding, there's a way in which it kind of, on first reading for me, kind of depressingly, I'll just say, made some sense. And then you think about it more, and there's something kind of insane about it. And so a lot of these things can just be really overwhelming on the first read. And then if you look at them and think about them more, you think, this is not right. And in fact, the repeal of the endangerment finding, to me at least, actually threatens programs beyond greenhouse gas programs. And I don't think that's going to be popular. I don't think that if I go all the way back, if I'm talking too much, tell me, but if I go all the way back to one of the biggest victories I think people think that EPA ever had, which is the phase down of lead in gasoline in 2 phases. If you look at that, the notion of causation at work there, the notion of responding to risks proactively under the Clean Air Act, those notions are kind of forgotten in the repeal of the endangerment finding. And so it strikes me, if you go back and think creatively about where we've been with clean air in this country, you can find examples that are just diametrically opposed to what the agency is doing now. And those examples can work, legally speaking. It just takes time. It just takes time to work through, I think, the legal process. Anyway, for what it's worth, do you guys have anything you want to?
I'll just add that I think that one of the reasons why prosecutors are interested in starting criminal investigations is because they want the attorneys at the companies to be aware of the risks that they are facing. I don't think the goal is retribution in some sense. They're really looking for any leverage to generate a settlement that will benefit all parties going forward. And so I think that the criminal law provides a level of leverage that most environmental attorneys are not used to thinking about. We're used to, I guess, my impression in talking to the folks at environmental law is that they're used to thinking about the federal law mostly, occasionally about state enforcement of state laws, environmental laws. They're not thinking about fraud, antitrust, public endangerment, child endangerment, homicide, negligent homicide, reckless homicide. These are the kinds of charges that I don't think these companies want to bring before a jury in a community that has just suffered a serious climate catastrophe. And those are more and more communities every single year. And so, to my mind, it is one way of bringing the very powerful players in this arena into a dialogue about how to have some kind of shared vision for how to move forward, given that type of leverage.
That's really helpful. I have no idea about this. So you're right, at least for an N of 1. But what about, I mean, do those create opportunities, the criminal prosecutions for the feds to come in, or are those just operating on different tracks?
No one that I know thinks the feds are going to do anything. The local criminal folks, the state level criminal folks, that no one is thinking that the feds, or not relying on any assumption that federal intervention will have any effect, at least for the foreseeable future.
Hi, that was a really great panel. I had a question about data. So we're talking in our property class last week about zoning data. You showed First Street Foundation data up here. I'm wondering what the role of data that's collected by increasingly sophisticated institutions like First Street is going to play in holding climate, in holding actors accountable. And so what I think about is I look at the First Street data and their maps, and it's undeniable that there's climate risk. So in what sense can we say that an actor who proceeds in light of data, like, again, this data that's being amassed, not only on flooding that we showed in Connecticut, but also on wildfire risk and everything else, that their behavior is rational. So I'd just love you to talk a little bit about how that might change judgments about private and public actors' behavior in increasing our climate risk through their policies and decisions.
Yeah, what a great point to raise. I mean, this is one of the things that's so interesting to me about the Connecticut example is it seemed like the state was, First Street was motivated in part because they thought the federal flooding data was out of date and not taking properly into account the climate risks associated with, or that could contribute to flooding. So that was part of why they began to amass this data. That was one of the reasons that Connecticut decided to share that data. We're also at a point in time where the federal government is eliminating access to data, stopping to collect data. And so there's this sort of massive push to capture the data that was already painstakingly developed. I think the private gathering of data, insurance companies is one of the things that, one of the industries collecting a lot of data that it would be nice to have Aisha's take on. It may end up proving to be perform a gap-filling function. And I think it's really interesting just to go back to Caroline's opening, where you made the comment that in the endangerment finding, it had the effect of sort of making the benefits of the endangerment finding or of regulating GHGs from mobile sources appear to disappear because of sort of shifting the way to think about it. I think one of the things, basically anything Lisa says about Clean Air Act and greenhouse gas emissions, just take as gospel truth, basically. And, you know, if there's no, if it can, like, let's say Clean Air Act is, you know, you know, is amended to completely alter the frameworks that we've become used to, you know, that is a move away from relying on data. It is encouraging to me that we're seeing in the COP process, right, as the US recedes from that setting, what's happening there? There, the parties are continuing to develop more and clearer and more reliable transparency frameworks. So enhanced transparency frameworks for what purpose? Synthesizing what the NDCs say. So nationally determined contributions come in lots of forms. My students in class last week took, each of them looked at 2 NDCs of countries of their choice to just compare and see sort of what was the context that is underlying the articulation of an NDC, what's the approach they took to submitting that, right? And what you see, so how is the UN supposed to synthesize that and say, are we on track, are we not? It's through kind of creating these common data measures. And I think private collection will assist with that, as they're now required every 2 years to submit biennial transparency reports that will help to create the commonality there.
I guess I'm thinking here about the government pulling back on its disclosure of data, and also as Caroline said, the practice of not quantifying and monetizing human lives lost to air pollution. And even though they backed away from saying that the science of climate change isn't certain enough for regulation, and didn't actually make that a real central part of their rescission of the endangerment finding, I think that the lack of data, the pulling away from data, the hiding of data, and the acting in the face of data showing a danger is itself a piece of fact, right? That in the sense that what we know with more certainty every day is that the federal government right now does not have our backs. And that's happening at a time when the effects of climate change are just undeniable. And so I wonder, this is speculative, but I wonder if that data point, the pulling away in the face of these risks, it just can't hold, right? It just, that kind of sort of hiding from the fact of the matter, I think just can't hold. And I wonder to what extent that will be regarded at some point as going too far. Yeah. Alex and then Alex. Yeah.
Great panel, and I'm so glad that you brought, you know, criminal, oh yeah, what's Alex?
Go ahead. Go ahead, just call me Alejandro.
You bring criminal law and insurance law, even though we don't have our insurance person, into the conversation. And the insurance discussion was making me think about back in the 1990s, Minnesota passed a pretty innovative law that was to follow up on some of the limitations of the original Superfund laws, state and federal, before we had climate Superfund laws in our, you know, in our vocabulary, where basically it authorized the Attorney General to take over the insurance claims of parties that were potentially liable for closed landfills, because you've got sometimes thousands of different parties. They each have insurance claims. You have a big collective action problem. And so they took over all those insurance claims and brought lawsuits against the insurance companies. And then they would get settlements to then do the cleanup of the landfills. And it was quite successful. And in some ways might form, you know, at least it could be a small version of a model that could move forward on the climate side. So something like that has been done before. And I'm also seeing more just sort of straight insurance law scholars starting to move into this field. My former colleague from when I was at University of Minnesota, Dan Forbes, who's an insurance law expert, is now starting to write a lot about homeowners insurance and climate change issues. So we're seeing the crossovers like you're doing on the criminal law side, which I think is super important.
Nice. Alex.
Yeah, so I kind of hate to do this, but so I'm going to draw on my book that's coming out on Earth.
Oh, I know you hate it, Alex.
Is there a
No.
slide?
No, there is not. I'm not going to be talking about it later. It's completely unrelated to what I'm going to be talking about later, or somewhat unrelated. But the conversation that's happening right now, it seems to be incredibly relevant to it. And hopefully it's a story of hope. At least it's descriptive about the past. So the book is called Lessons for a Warming Planet, A Vital History of U.S. Environmental Law. And its primary focus is looking at environmental laws not starting in the 70s, not starting in the 20s, but actually starting in the 1780s, talking about the ebb and flow of U.S. environmental law, of currents and undercurrents, and conflict between idealists and pragmatists, and learning from different scales. And so I just wanted to put out that I think the most heartening lesson from this sort of deep and often depressing dive is that prior generations deployed legal imagination when faced with what seemed to be to them insurmountable environmental challenges. Yes, there were leaders. Yes, there were social movements. Yes, there was political coalitions. Yes, there was information. Yes, there was technology. But these were catalyzed by the law. And in turn, they also advanced legal change. So, I mean, public land reservation was revolutionary as an idea in the 1910s. Many of us think of it, the NEPA, Clean Air Act, Clean Water Act, were incredibly creative. And I think the challenge for us as environmental lawyers a lot of times is that we're so steeped in the statutes and the technocracy of it, is that we start thinking of incrementalism. And I realize it's kind of flipping me to say, though, repealing danger environment is incremental. It's not to many of us. It's a revolution in many ways. But if you take a wider aperture, it's actually a relatively small thing. It's not to say it doesn't have major consequences. So I think in many ways, I think this panel is great because I think what the challenge for us as scholars and policymakers as well is, or for students actually, is to communicate better, not just to the public and policymakers, but among policymakers and scholars. For example, this isn't a criticism. California does have something similar to what Connecticut does in terms of you can go on Google Maps and any person that wants to check on Zillow or whatever, when they look at their property, they will see wildfire risks, sea level risks, etc. Same idea.
Didn't Zillow take it off though? They said they weren't.
Zillow might have, but California still has.
They still make it available.
California still has the database. So I mean, the point isn't that. It's more to say that there's so much happening that in many ways, for us, the job as legal scholars and students too is to roll up our sleeves and join the fight to make them a reality. I think a lot of us part of our jobs is to come up with imaginative ideas, and part of it is to actually communicate these ideas and try to make them happen. So that's a hard thing for scholars to actually do. It's easier for us to just say, this is a good idea. Actually trying to roll up our sleeves and actually make it happen is a real hard challenge. But I want to commend Don and others for joining into thinking about the imagination. The tools are not just the Clean Air Act. The tools are insurance, criminal law, administrative law, changing the corporate form, ending limited liability. I mean, I know that sounds revolutionary, but that might be what is necessary.
I love those
Fun
remarks.
for that.
Can I just quickly say something? I love those remarks, and I'm really interested to read that. I think it shows, like Alex's example from Minnesota, that's an example. People seeing a problem, coming up with a solution, figuring out what's going to work, and that does have this long history, so I'm really looking forward to reading that. I think it also is just a reminder of the, when we do get myopic, right? And we don't only want environmentally myopic focused people in this. So one thing that I did at KU was I started to teach the climate class. Well, I've done it twice. I did it at Washington, St. Louis, and now I'm doing it at KU, teaching climate as a 1-credit class because that's a lower commitment of time for people who don't think of themselves as environmental track. And so it brings in more of the people who plan to do business, who plan to do criminal defense or criminal prosecution. It's people across, they want to know, they are interested, but they don't think of themselves as environmental track. They're not going to take a 3-credit environmental class. It's led to some really interesting conversations. So I think the more, whatever are the ways that we bring people into the conversation and realize that there's so much intersection between different areas of law that are going to be increasingly affected by climate. And that's why the bar associations see that as part of representation across many law practice fields.
And back.
I'm also through GW. I am a law clerk at our Children's Trust right now, and that's a nonprofit doing a
mean, I'll say that there's nothing more traditional than a state using the criminal code to protect citizens from lethal and other types of harms, right? It is one of the most traditional, and in our federal system, a right that states have and a power that states have that is immune to the kind of preemption that we see. Almost all of the state criminal laws are immune to preemption, except where they explicitly do things like duplicate going after a federal officer or something like that. The same is true for corporate law, right? Corporate law is anchored in the states. And so states have a special ability and duty to govern the corporations that conduct business in their states. And so I'm not sure this is getting exactly at the substantive and due process parts, but I will say that, you know, the attorneys general and state and local prosecutors care deeply about their communities and protecting them, and also granting the people who they bring before them substantive and due process rights. But they also have a number of advantages that I've talked a little bit about this, but the causation standard is different for most criminal law across the country at the state level. Arguments for causation that would fail in federal court and that would fail in civil court succeed in criminal court because under the modern standard, causation issues are thought to be issues resolved by the jury, not by the judge. And so while that might not mean much to folks outside of environmental law, if you've seen the causation standard as a barrier to your work, you should come take a look at the criminal law because it is no longer the barrier that it once was. And the same is true, and I can't really speak as thoroughly about corporate law as Teresa and other corporate scholars who are doing this work, but it is very much the case that states have the power and the ability to regulate corporations through the chartering mechanism and to put the kinds of purposes back into the charters of corporations that we have over the last century stripped out of them and said, you know, basically you can do whatever you want to generate some kind of profit. And what they, you know, that means that they are heavily incentivized to externalize every cost that they can get away with. And so if we can put some of that consideration back into the corporations operating at the state level, I think that that could be a significant benefit moving forward. I think that this also goes to this point about creativity. I think that we're all trying to figure out how to add this kind of creativity and information to our curriculums, right? In criminal law, you basically learn how to prosecute poor people. And that is not what criminal law should be about, right? Criminal law should be about how do we use the law to protect the public. And I think that we need to restructure the criminal law curriculum to teach students how to do that when they get out of law school. I think that the same is true for corporate law. We need to restructure how we teach corporate law so that we harness the power of corporations to help our people. We have this incredible invention that does so much good, and yet it also does so much harm. And we should be teaching students how to regulate corporations so that they prosper by doing good rather than by doing harm. And we don't do that right now in corporate law. I think that there are lots of other opportunities in international law and so on and so forth, and we're just starting to figure out how to do those types of things. I think that's a long non-answer, so I apologize for that.
Great. Rob.
So I want to ask a question about the role of real-world events in spurring legal transformation. So Caroline talked about the fact that climate change is already occurring. We're dealing with it now. And people are, if you believe the polls, becoming more aware of the effects of climate change. but that awareness has not grown as quickly as I would have hoped. And over the years, I've sat back and said, okay, so Hurricane Katrina, that's going to do it. People are going to wake up and demand that society do something about climate change. Well, it didn't happen. All right, well, it's going to be Hurricane Sandy. Didn't happen. It's going to be these wildfires in California and other places in the West. People are going to basically say, okay, we've had it. Something needs to change. So Chris Schrader, who was an early environmental law professor, used to talk about Republican moments. Moments that basically coalesced in a way that spurred and enabled transformative legal change. And my question is, do you see real-world events like extreme weather events, wildfires, other effects of climate change having the capacity to give us another Republican moment where the public demands and politicians respond in a way that creates some of these creative legal transformations that we've been talking about?
I think that's really complicated. I think we have had a Republican moment, if you think about a major statute, right, to take on climate change. We've had that, the Inflation Reduction Act, right? But it wasn't durable. So I don't know to what extent we have these moments and then everybody declares it finished, right? I think it used to be, we had, you know, not to get Pollyanna-ish, but we did have statutes that sort of came along and lasted a long time and whose meaning was settled eventually. But I don't think we even have that. And we have now the strange, just to get back, because it's so much in the room today, but to get back to the endangerment reversal, even a Supreme Court case holding that an agency has power, that's not durable either. So I don't know, but I don't think we should be waiting for an aha moment. I think any one of these disasters might have been enough. I mean, the Cuyahoga River caught fire and we had a Clean Water Act. I mean, there's been plenty of Cuyahoga River moments in climate change. But I don't think either we should take the lack of a major national moment as the meaning that people don't understand what's going on. And I think that sometimes we mistake a kind of factual denial. We think that people are factually denying the existence of climate change, when in fact climate change is an unbelievably difficult problem to wrap your mind around, and people would rather not do that. And some of the thinking about psychology and climate change recognizes that most people, if you think about, we could ask anyone in this room, what is your favorite place in the world? What is your favorite natural place? What's your favorite, do you have a tree or a lake or a river or something like that? Most of you do. And people, when they see those things going by the boards, they don't necessarily think I'm going to take action. They think, well, maybe I'll move to a different lake. Maybe I think it's really, really complicated to take it on board. And I think that the insistence that it's all about people having more scientific information, I think really ignores that basic feature of human hearts.
I know we just have a couple more minutes.
Yes.
So should we do more questions? I would love to talk with Rob more about this, but did you want to get more folks or should we?
Yeah, YouTube. I don't know your name.
Oh, sorry,
Yes,
Mariella.
yes.
I'm a 1L. I was just interested in the settlement approach, and I also am someone who thinks more of like in a restorative justice, but I wonder if that creates an incentive to companies who are making billions of dollars in revenue that, oh, okay, we'll just set aside a few million or 100 million for a settlement this year, and we can continue doing horrible things, but because our revenue is so large that, you know, it won't really be a problem in the grand scheme of things. And so how approaching the settlement approach, but also deterring people from continuing their actions will go hand in hand.
Is that for me?
Yeah.
So I think that's absolutely right? This idea that if you have enough money, you can commit crimes with impunity and just pay fines to get away with it. That's not justice, and that's not what people are looking for. I think that's why we're trying to figure out how to have more structural change, that we use the leverage of criminal enforcement to bring the folks into some kind of agreement on. And this, it's not crazy for states to have corporations incorporate in a state and abide by state incentives. And I think that that kind of structural change where you're putting a lot of enforcement hooks into corporate charters is a very different kind of rehabilitative, restorative. And in addition to all the other things that people have already been talking about. I mean, I'm focused on this one thing because I think it's distinctive, but there are lots of solutions that states are thinking through that they would like to bring large corporations to the table to work on. And the question is, how do you get them to the table, and then how do you make it stick?
That's all the time we have. Thank you so much. Thank you to
Thank
Brennan
you.
and to Don for great